following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori?
Good evening, everybody. Welcome to the following program. I'm your host, Joe Nierman, a.k.a. Good Lawgic. My apologies out of the gate that I had a late start tonight. I warned y'all that if you want to know what time I'm starting, you really need to sign up at Locals because that's where I keep notices, especially this week. I'm going to have very erratic schedule times because I am in the midst of participating in a week-long celebration of my daughter's wedding. Multiple parties being thrown by various friends and family. So, yeah, when and where I'm going to be here is hard for me to say even 24 hours in advance. Like, I can't tell you what time I'm going to start tomorrow. I have a general idea. That's probably not going to be on time. It'll probably start like tonight. But if you want to know when and where you can find me, you really need to check out goodlogic.locals.com. And one of the things that you will find out when you get there is that tomorrow I will be live streaming, God willing. I believe it starts at 2 p.m., but I'll start probably 15 minutes before 1:45. The continuation of the Fani Willis hearing. That's right. We got a continuation. You might recall that last week, Nathan Wade filed a brief telling the judge, hey, you're not allowed to have any more in-camera conversations. That too would be a breach of attorney-client privilege. I labeled that. I think the label I called it was terrible motion, lousy motion, pathetic drivel. I'm not sure exactly what did I word it here? Oh, this is I got it. This is this is, I'll show you. I don't toot my own horn unless I can back it up. And right. And when I back it up, it better be tooting pretty loudly. So yeah, what I'll share with you here is this was the thumbnail that I created for that stream, which I had last week. Right here. Wade is terrified, begs court for help via terrible. See how big it is? Terrible. Hail Mary motion. I even had myself doing a little Hail Mary myself in mockery of him. That is me, although I guess you can understand how I look like I'm like from the Holy Members of Beneficence or something like that. But yeah, that is actually me. And I was saying a prayer for him because he needed our prayers. Nathan Wade needs our prayers. I said that motion's not going to work, and it didn't. His motion died. So much so that the judge said, hey, you know what? Denied. I don't need to hear from opposition. I don't need to hear opposition on your motion about this. You lose. So if I tell you a motion is I'm very look. I'm not going to kid you. Okay. I'm human. We all have our blindnesses for what we're sometimes what we reason to be something versus what we hope to be something are not always in such unique concert with each other, and sometimes we might see things with rose-colored glasses. If I tell you emotion is objectively terrible, and I don't see it working, even whether it's for me or against or for my side, so to speak, in concert with, let's say, agendas that I support rather than those I may abhor, that I'm trying to give a very fair analysis. So, for example, when I described his motion, I called it terrible because it was. I was like, this is not going to work. In contrast, I said, look, the state's application to keep out the phone evidence is stronger than the Wade motion. I don't know if it's strong enough to keep it out, though. That one requires response. And we have response. We will review that response together. I haven't had a chance to look at it. I glanced through it very quickly, but I haven't gone through it yet. And the response from Steve Sadow, who wants to get his geolocation evidence recognized as valid evidence and part of the record in this hearing. So where are we at now? Where are we at this current juncture? I'm going to give you a little outline as to what I intend to do tonight. Okay, because I am supposed to finish at 12, but I'm probably going to run long. I'm probably going to run a little long. Not going to kid you. I'm probably going to run a little long. So this is the agenda I plan on covering with you tonight. Okay, first I'm going to go through basically what we should anticipate happening tomorrow, and how there's going to be a hearing, and what this is about, and what we could take, what gleanings we could have from the judge's actions so far. What's a reasonable interpretation as to where his mindset may be at. That will include some speculation on my part based on my experience and based on what we've seen. And again, when I'm doing that, that could be mildly rose-colored. I'm not going to kid you. One can't, if you're denying the possible existence of there being a leaning in that you fight with internally, then you're completely a homer. So you have to at least recognize that and try to just sort of caution yourself against, like, okay, let's try to take off any rose-colored glasses. So I do my best to really try to do that, because there's no benefit to you in me misleading any of you about prospects of success or failure. I can't stand when people are just like, constantly trumpeting like, oh yeah, unleash the Kraken and all that other crap. I want to give you truth. And the only way I can give truth is if I do my best to take off rose-colored glasses and say, okay, this is what just to me seems logical, seems fair, seems reasonable, given the facts that are laid out. What can be reasonable and a reasonable interpretation, whether or not that reasonable interpretation is something that I'm aligned with or something I oppose. So the first thing I'm going to do is I'm going to look through what it is that the judge has done so far since we last saw him, and where we're at coming into tomorrow. What we should anticipate for tomorrow. We'll look through a couple of articles which are laying out the testimony that's going to be coming in. Then I want to share with you some evidence, and we're going to actually review with you very, very short clips that I've pre-selected and set up here from the testimony of Nathan Wade and Fani Willis, where I was like thinking about the different testimonies that they had laid out, and I saw a direct contradiction in their testimony. Completely, where one of them must be lying. One of them cannot be telling the truth. It's a flat out lie. Like, if you believe what he says, then she's a liar. And if you believe what she said completely, then he's a liar. And I'm going to show you the exact contradiction. And I'm going to show you the brilliance of Steve Sadow, where he set this up, which makes me feel confident that he recognizes it. I'm not sure if he can fully. I'm not sure. I expect, because he seems to be a fairly intelligent, very intelligent attorney. I'm going to go from fairly, I'm going to raise him up a bar and say he seems to be a very intelligent attorney. I think he fully gets it, but I want to walk you through what I think Steve Sadow is holding in his back pocket, that he's going to basically walk the court through when he gets to closing arguments, when we eventually reach that closing, which may be tomorrow. I don't know if it's going to be there tomorrow. So I'm going to try and set you up so you can be prepared for that. And share this with your friends and show you the exact moment where his statement is a direct contradiction to Nathan Wade's testimony is a direct contradiction to Fani Willis's testimony. And I haven't seen anyone else talking about this. So I'm going to basically try to walk you through that. And then I'm going to close out today's show by going through Steve Sadow's reply to the Nathan Wade the district attorney's opposition to the admission of the phone records as evidence in this hearing. And we'll see how strong his reply is. I told you that the district attorney's opposition was stronger than Wade's. Not great, but definitely stronger than Wade's. And we'll see what he has to say about that. That's our schedule for tonight. So lock yourselves in, get out your popcorn. Let's get this show rolling. Let's get it rolling. Before I get to that, let me do a few little things I got to sort of cover off here. Oh, in case those of you wondering about the wedding that I had last night for my daughter, it was beautiful, really beautiful. I'll tell you right now, I at a certain point, at a certain point during the wedding, I actually lost it. I did. I'm not gonna kid you. I was just like, I got very, very moved by something that my new son-in-law did. It was just the way he conducted himself, like during the course of the wedding. I was very, very moved. And then the dancing and the music, it was off the hook. And people were just like it was just like very high energy. So after the wedding ended and we had the reception afterwards, it was just crazy high energy. And it was amazing. Thank God. Everything went off like really well. Feel very, very blessed to be part of his family and to bring these young men into our fold. He just seems to be awesome, like really, really awesome. So thank God. Lady Lawgic and I are very, very pleased. My daughter, thank God, seems like she's on cloud 9. So yeah, those of you, and again, I want to express my gratitude to those of you who have expressed interest or questions or whatever concern. I just want to say thank you for that, as well as those of you who very, very generously contributed to help ease that financial burden for me. I greatly appreciate that as well. So I want to say thank you. Scale of 1 to 10, how beautiful was the bride and did you cry? Oh, you see, I didn't even see this question yet. She was an 11. She's naturally a very, very, very pretty girl. She's a strikingly pretty girl. And she looked awesome. She looked phenomenal. And yeah, I did break down during the under the chuppah is what they call it. Like, you know, when you're up there on the podium and they have the thing overhead. I lost it there. My 9-year-old, who's very close to the bride, because they're like the last 2 girls in the house, and like their brothers are all off in school, so they're basically the ones who are here on a day-by-day basis. She lost it. And like it's gonna be an adjustment for her, but she's strong. They look exactly like my 9-year-old looks exactly like what my 22-year-old looked like 13 years ago. So thank you so much, Sylvia's daughter. Today's my birthday. Happy birthday, Kimmy. I had the Beatles song in my head all day because I made 64. Oh, na 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 na. Many years from now. Na 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 na. I don't know the lyrics of this song. Will you? Na 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 na. Well, happy birthday, Kimmy. That's awesome. Awesome. Eric Weinberg gifting a membership. God bless you, brother. That's very thoughtful of you. Thank you so much. Petty T, can Fanny just step down and resign to make this hearing stop, or does the record need to continue? Very good question, Petty T. I will tell you this. If Fanny and her office, because it's not just Fanny, this would affect her office. If Fanny and her office and Nathan Wade all step down, that would be granting the defendants the relief that they're seeking. And theoretically, this bludgeoning would stop. Theoretically, it would stop. It would end there. That could happen. However, March 7th, there is now an ethics investigation. There's supposed to be like a whole thing that's starting looking into their ethics, which is commencing on March 7th next week, which I will be live streaming that as well. So that's going to be next week. I'm glad you raised that question. It's a great question. And that's the best answer I can give you. Thomas Burton, God bless you, brother. 10 good Lawgic memberships. Those of you who are new members of the following, because that's what you become when you get gifted a membership, you become a follower. Those of you who are now members of the following, you're followers of the following. I need to point out a few things to you. First of all, the following is not at all a cult type of cult. Many people here in the chat will lie to you. I know as I'm saying this that they are lying. We sit there saying it's totally a cult, it's totally a cult. It's not a cult, and I can prove it. Here's the proof, okay? There's no Kool-Aid, no spaceships, no self-harm, no harming others, no tracksuits that are mandatory, only on request, mild farming, no squirrel mutilations, no goat sacrifices, no throwing blood on walls, no vomiting staccato. It's literally the least culty type of cult ever. ever. So and I am not the leader of the following. I'm just a follower, just like you. So there you go. Welcome, all you new members. Congratulations, Brian Grimm. Thank you, Ed. You're too kind. Any columns knocked over? Thank God, no. No columns knocked over. That's for another day. Let's get into it. We have a lot to cover here. We're going to start with this story from the Politics Brief, which says, Judge rules no attorney-client privilege for witness who can blow the Fani Willis scandal wide open. Wide open. Oh, yes, he can. Judge McAfee has concluded that the attorney for Nathan Wade must retake the stand at the Fani Willis hearings and that he must answer questions that are not protected by the attorney-client privilege. A witness in the ongoing Fulton County District Attorney's disqualification controversy met behind closed doors. You know why they met behind closed doors? Because the judge said to Nathan Wade on his whole motion, you lose. You lose. What a stupid motion. I don't even need opposition to tell you, you lose. So that's why he had these closed door meetings. He's spoken to Terrence Bradley. He knows what Bradley is likely to be testifying about. He knows. Judge McAfee knows. He's like, oh yeah, this case is done. This case Fani and Nathan are in trouble, and there's nothing like if he's going to be a fair judge, which he seems inclined to really try to be a fair judge. There's nothing you can do to bail him out. There's nothing you can do. They made their own bed. They wet it. They basically crapped all over their own bed, and now they're just wearing it, and they're just like rolling around in it, just rolling this way, rolling that, and they're like, ew, there's feces all over you. No, that's just what they're doing. They chose it. No one told them to do this. You didn't have to do this. You could have just owned up. If they were smart, if they were like intelligent, they would have been like, yeah, okay, we had a relationship going back years, predates when he was hired. That doesn't mean we felt he had all these different qualifications and there was no money. There was no money exchange. But no, it's not the road they went. They went the way of the liars and the stinking liars. Understand the irony here is that these two fine, upstanding members of the court are saying we have to throw the president of the United States in jail for falsifying records, for perverting justice. And that is precisely what they have done. Precisely what they have done. It's like you can actually picture God up in heaven looking down and just laughing. The witness, if you can't picture him, you can picture me. I'm a terrible facsimile. Terrible, like not even. But you and I together, we can laugh at the irony because the irony is just hilarious. The witness, Terrence Bradley, is a former law partner and one-time divorce attorney for Special Prosecutor Nathan Wade, the report continued. Quote, defense attorneys have asked Fulton County Judge Scott McAfee to disqualify both Wade and District Attorney Fani Willis, alleging they financially benefited from a romantic relationship they shared during their ongoing prosecution of former President Donald Trump and co-defendants accused of interfering with the 2020 election in Georgia. The development was also noted by legal analyst Phil Holloway on X, and I thank you, Phil, because certain people tagged me in this to call this to my attention, and this was the first place that I had seen it. The judge rules no attorney-client privilege for Fani Willis, Special Prosecutor Nathan Wade's former lawyer. See, this means he will have to testify about potentially incriminating texts and other information that could prove Willis' affair started earlier than she said. And we're going to look at that, and we're going to look at where they controverted each other. And this is something that I'm going to ask you all, someone, clip it when I'm up to it, not this part, to clip and make sure Steve Sadow sees the precise contradiction so you can understand the ramifications of this. Because I did find a spot about material testimony made by Nathan Wade that directly contradicts material testimony made by Fani Willis on issues that are highly material to the subject motion to have him removed. And I'll walk you through it. We're not there yet. First, we're going to go through what's happening tomorrow, which we're almost done with that. Quote, judge rules no attorney-client privilege for Fani Willis, special prosecutor. Nathan Wade, former lawyer. Holloway remarked, quote, this means I've testified potentially incriminating texts and other information that could prove Willis' affair started earlier than she said. During a tense hearing 2 weeks ago, defense lawyers spent hours trying to persuade Bradley to answer questions about then Willis and Wade's romantic relationship started. Bradley, however, refused to answer, arguing that any information he may have obtained during his time defending Wade in his divorce proceedings was protected by attorney-client privilege. Judge McAfee appeared to accept Bradley's reasoning until he responded late in the day at a hearing earlier this month, reopening the matter. Quote, Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege, Judge McAfee said February 16th. When asked by the state, Anna Cross, deciding to try to humiliate Terrence Bradley so that for reasons it's difficult to really fathom, perhaps just because she's district attorney and that's what district attorneys feel like they need to do. She is the one who put the nail in Fani and Nathan's case because she showed this judge that Terrence Bradley will claim privilege when none exists. All day long, hours of testimony. Every time we thought, oh, we're going to get some answers here. Get some answers. A guy here who knew all about the relationship, when it started, what's happening there. No. Privilege. Is that how do we know it's privilege? But yeah, they would ask the witness, Terrence Bradley, is it privilege? Yeah, it's privilege. Oh, okay. Is it privilege? Yeah, it's privilege. Is it privilege? Yeah. Objection, privilege. How many, when did he tell you about going out to dinner with her? Objection, privilege. Is it privilege? Yeah, it's covered by privilege. Okay, sorry, next question. Sorry, next question. Over and over again, that Judge McAfee relied on Terrence Bradley saying it's privilege. Now, even when he was saying it seemed like a very, 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 very broad interpretation of privilege. Now, to be fair, let's assume I'm going to give Terrence Bradley the benefit of the doubt here. I'm going to give him the benefit of the doubt because one of the things you need to understand, I'm going to close this for a moment. We'll come back to this, but I just want to explain something to you. Attorneys are terrified of breaching our ethical responsibilities. I know that might sound comical to those of you who think that the word attorneys never belongs in the same sentence as ethics. But there are rules of ethics, which if we breach them, the reason we're terrified, by and large, as a group, can be for one of two reasons. It's either because, well, we tend to be very high integrity individuals, or that's one possibility. But the other possibility that we might consider is that if you have a serious enough breach of your ethics, you can face discipline and be suspended from being able to practice law, if not disbarred. So you always try, anytime you know that you're starting to traverse into an area where this really could be a breach of ethics, we as a group tend to be very, very careful and tread very carefully. Those of us who treat our law licenses seriously, because we're afraid that someone's going to misinterpret what I'm saying, or I'm misinterpreting something, and then an ethics committee is going to look at this. The Office of Court Administration of my state is going to look at this and going to say, "How dare you breach your ethics? You're now suspended for the next 6 months or disbarred. You could lose everything." And this is what you invest your whole life into building. So you sort of like, I'm not walking anywhere near there. Now, when it comes to privilege, there is the attorney-client privilege, and where it attaches is murky. It's really not very clear. I mean, it's murky not in the rule, but it's murky. The rule is fairly clear in most jurisdictions. Probably, I would assume, in all jurisdictions. The application of that clear rule becomes a lot murkier. Especially when you're talking about people who know each other for a long time. It's much murkier when you're talking about Terrence Bradley and Nathan Wade, who go back 30 years and know each other as friends and whatever, but going back before they were lawyers. and then they form a legal relationship at some point. That is one of the murkiest possible situations you can have, because now when you're having conversations with him, when you're sitting there as his attorney in court and you ask him a question like, what do you want? How should we address this? And whatever, you're obviously acting as his attorney there. Anything he says to you is protected by attorney-client privilege. And if you breach your attorney-client privilege, you, the attorney, the one who gets in trouble, not the client. You're the one who gets in trouble. You're the one who faces discipline. So if you're Terrence Bradley, you're always safer if you just regularly saying, it's privileged. It's privileged. Now, there might be, let's say he's just having a conversation with him about, what happened in the Hawks game. That's clearly not covered by attorney-client privilege. Well, what if you start talking about Fani Willis? Well, it depends on the nature of the conversation about Fani Willis. If he comes to me, he's like, look, the last thing I ever need is for my ex-wife to find out the fact that I was with Fani Willis last night, so that can't happen. That seems like it's definitely privileged. But if he comes to him and he's like, dude, I just finished, if he comes to me and he says, hey, Fani Willis is thinking about hiring you to become her lawyer and work for the state in a taint case, that's not privileged. It starts getting a lot murkier when we start talking about his relationship with him in general. It also is very murky as to when he became his lawyer. When does that relationship commence? Because if you walk into my office, I'm sitting here as a practicing attorney, you walk into my office and you come in for a consultation, even if I don't charge you for a consultation, which would make me an idiot, but unless a personal injury attorney. But yeah, most attorneys going to charge for that initial consultation. But so now if you come in there and you come and I'm not charging a consultation fee and you're asking me legal advice, even if you don't end up retaining me, there likely is a sufficient attorney-client privilege, a connection there that privilege would attach. That if I would go and start telling people about what you told me, that I could be facing disciplinary action for that breach. It's very, very strong. It attaches pretty quickly, but it doesn't attach to every conversation you have with that person for the rest of your lives, especially if you're business partners, law partners, you're talking about some other case. If Terrence Bradley is the attorney for Nathan Wade, and all of a sudden John Smith comes in as a client to talk about some, products liability case, and the two of them sit together and they have a conversation about it. It's not like everything Wade says to Bradley is privileged. None of it's privileged, at least between them. It might be privileged to the third party, but not privileged between each other. That Wade could say, I have a privilege that you can't talk about it. The client would have that privilege, but Wade doesn't have any privilege. It only is to the scope of the representation. And that's why now, if he talks to him about conversations, he's like, hey, I hooked up with Fani last night. Oh, I'm sorry. Let's say he says this. I'm coming in late to the office today because I was out with Fani. I was out with Fani until 4:30 in the morning. I just got back from her place at 4. Yeah, I just got back home. I was out with Fani until 4:30. I just got home now, so I'm not going to be coming in until 11. Is that privileged? It shouldn't be. This doesn't make any sense. He's not telling him that for the purposes of him being a better divorce lawyer for him. So the application to most people would be like, that's not privileged. There's no way in hell that's privileged. He's not telling him that so that he can be better counsel for him in his divorce case. He's telling him that because it relates to their whole business relationship. So you can see that there'll be times to be talking about this relationship that's definitely not privileged. But Terrence Bradley, in an abundance of caution or loyalty to his friend or fear because he's being blackmailed, as some people claim, that he's being threatened, that if he talks about this, that he's going to face the wrath of God, or he might face SA allegations from the state, which is another threat that that people say that he's being blackmailed. So for a host of reasons, potentially, some of them more noble than others, he gave a very broad application of, oh, that's privilege too. Well, that's privilege too. Everything's privilege. Everything's privilege. So anytime you ask about anything, I saw nothing. I see nothing. He also turned to like Sergeant Schultz. I see nothing. I know nothing. Or anything I know is privileged. And then Anna Cross has to get up there and try and embarrass him about these SA claims. After he came up there, he said, when he was asked about why he split off from Wade, and when he's being asked and questioned about this, he says, I can't talk about that. That's privileged. I'm like, It is? Is it related to that's privileged? Really? Is it related to Fannie Willis? And he's like, yeah, it's privileged. And then Anna Cross has to try drilling him afterwards. So now he called this privilege, he called that privilege. And when he starts preaching that quote unquote privilege about why he left the firm, and it's about SA allegations, which have nothing to do with privilege, might be confidences, but not privilege, it becomes clear to Judge McAfee that this guy doesn't really understand when privilege attaches, or if he does, he applies it so liberally, far more liberally than he's allowed to under the law. When he's being drilled and questioned. Now, there is a difference between privilege and confidences, and I've talked about this as well. You need to understand this, that something said to someone that you hold a confidence. If you and I if I tell you a secret, right? Let's imagine I tell you that I have a new video idea. You're a video creator, and I come and I want to hire you to help me like produce a series of videos. And I'm gonna want to hire you, and I'm like a little concerned, like I don't want anyone else to steal this idea. You might go to some other talent who's far more talented than I am, which is pretty much 97% of people on the internet, and you might suggest that they do it instead of me. So I might have you sign a non-disclosure agreement saying whatever the ideas I'm going to share with you, you are not going to discuss with anyone. That creates a confidence between us. That's not a privilege, it's a confidence. And that there's a penalty to you that would normally be written into that NDA, the non-disclosure agreement, which would punish you if you breach that confidence. Every non-disclosure agreement has exceptions that you're allowed to breach it. You're allowed to disclose those confidences, and I would have no claim against you. Like if you were brought up in front of a court and a judge directed you to answer those questions. Almost every NDA has exceptions for that under subpoena, you have to answer that. And it's very likely that what happened with this whole divestment, this whole split apart between Wade, Bradley, and Campbell was really an NDA. But Terrence Bradley confusedly referred to it as being privileged, not confidential. And once he did that, he basically showed the judge he doesn't really understand what privilege or confidence is, which is really not a great marketing thing for someone who's going on national TV and testifying as a lawyer to basically display such ignorance as to distinction, as to not understand the difference between privilege and confidence. But it almost certainly is that he was confused between privilege and confidence. And if it was confidence, well, in that case, even if he made a commitment, let's say he paid off some woman not to come after him, so he probably would have had an NDA signed. Then the NDA wouldn't stand in the face of Judge McAfee asking him questions. Judge McAfee could still ask him questions. The NDA would go away with respect to those questions that he's being questioned about. Or if one of the counsel would ask him about it, it wouldn't stand up to that if he's there because he was hailed in there by a subpoena. Completely weak, obviously much weaker than attorney-client privilege, which basically stands as a shield and blocks any conversation about what you spoke about. It's much stronger privilege than confidence, much stronger. But he's using privilege here, privilege there, and it certainly didn't apply with respect to his leaving. And the judge didn't realize this, though. That's the beautiful thing. He didn't realize how ignorant Terrence Bradley was. You know who was determined to show the judge how ignorant he was? Anna Cross, Assistant District Attorney Anna Cross. By drilling him and trying to humiliate him and getting him to start to own up as to why he left, it became crystal clear to Judge McAfee and any other attorney who was watching this. When he said privilege before, he was crazy. That's not privilege. There's no way that's privilege. So he doesn't understand what privilege is, which made McAfee basically say, how did I rely on this guy to start telling me what was privilege, and when I can see his application of the term privilege applies in situations where the law does not make anything privileged, which makes me really concerned that all this time that he was saying that I can't talk about Fani and Nathan's relationship because it's privileged, I think he probably was a little too broad there too. And that's why they end up having this in-camera conversation, this back office where he's like, all right, I don't know, some stuff there might be privileged, some it might not be privileged. I'm not having that on the record, but I want to have him come in. I want to sit down and talk to him so I can figure out whether or not he interpreted privilege properly when he was answering questions as to what was privileged when he was being questioned about how long in time Willis and Wade were going out with each other, what he knew. And it's clear he knew a lot. This is becoming crystal clear. And based on the phone evidence, it's becoming very clear that this will, when you talk about people who had 2,000 phone calls during 2001, they got on the stand, both of them got on the stand and swore to the judge that they did not have a romantic relationship before March of 2022. He's hired in November 2021. November 1st, 2021 is when he's hired. And they said, no, our relationship didn't start till months later, March, April 2022. And yet somehow, the year prior in 2021, they have 2,000 phone calls and 12,000 text messages, and they're basically on their as far as texting and phone calling, they're like a couple of horny teenagers. I mean, seriously. I mean, you wonder how the hell they got any work done. That's a lot of time. I mean, they weren't sick of each other. And for someone to say that's not a romantic relationship, I mean, come on. What the hell? What is that? What the hell is that? So, and fairly obvious, there's no way he could have kept that secret from Terrence Bradley, who's his law partner. There's no way. There's no way he wouldn't have known everything about that. And is his law partner really knowing all about that because that Wade is telling him that so that he's going to be a better divorce attorney for him? Doesn't seem to make sense. The guy doesn't seem to have 10 seconds to sleep by himself. It doesn't make any sense at all. You have to imagine there were times that he had to come in late because literally he was out all night long, basically doing Fani work. Interpret that whichever way you like. So that's got nothing to do with, I'm only telling. He's not telling. Here's the point. He's not telling him that because he's his divorce lawyer. He's telling him that because he would be telling the same thing if he was not his divorce lawyer. That's how you know that privilege isn't attaching to it. So, with that, here's the thing. So now they have this in-camera meeting, and I gotta tell you something. It's almost certain that by now, Judge McAfee knows all of this. He's not a stupid man at all. He happens to be a fairly intelligent judge from what we've seen so far. He saw right away. He's like, now I have questions about whether you understand privilege. A lot of judges wouldn't have said that out loud. A lot of judges would have been like, or they might have even realized it. They might have just been asleep at the wheel. Not Judge McAfee. He's been steadily gaining a lot of respect. He's been earning that respect. Okay, so, and I want to point out one more thing that someone asked me this question. Someone asked a question that I was like, I really need to explain this distinction because this is a very important distinction. Someone was comparing it to the attorney-client privilege that was breached by Trump and saying, you see, I guess attorney-client privilege is not really a thing anymore. And this is like further evidence of that. This is not in any way, shape, or form similar to attorney-client privilege as Trump. When they breach attorney-client privilege and they say, it doesn't count here, they claim there's a crime that the lawyer was helping them commit, and there's no attorney-client privilege when you're committing a crime. So it's not a claim there. The reason there's no attorney-client privilege here is because there never was attorney-client privilege for some of these conversations. That's the point. This is what you need to understand. It's not that the judge is saying, I'm knocking off attorney-client privilege. He's saying, attorney-client privilege, yeah, you became his attorney. And there is a privilege for a lot of things you said, but there's also a lot of other things you said that there never was any privilege that attached at all. Because it doesn't attach unless you're sitting there, unless he's telling you this information to enrich your ability to represent him in a divorce case. But for any other context, he's telling you that there is no privilege. So what the judge here is doing is he's likely saying this part, this section here remains completely privileged, always was, always will be privileged. These parts here, where you were just talking as bros or as business partners or whatever it is, and you happen to be talking about who it is that you're shagging up with or the late nights and the texts and the phones and whatever and all this other stuff, that never had any privilege at all because it's not part of your representation as his divorce lawyer. Completely completely 100% contrasted from Trump's attorney-client privilege that got thrown in the garbage. Because they actually are saying, yeah, all of this is privileged, but we're going to punch through that privilege because we think there are exceptions to where this privilege does not apply. So it should be privileged, but because of the fact that you're engaging, that the nature of these conversations that you thought you're talking to an attorney and it's protected, it's not protected because we claim that he's helping you commit a crime, that the lawyer is helping you commit a crime. Which is kind of really backward and stupid because basically we're going to say, I'm going to help prove that you committed a crime. So I'm going to assume that you committed a crime and that your lawyers helping you commit that crime. That's going to enable me now to breach the privilege, even though I haven't proven you've committed any crime. So now I'm going to use that. It's like you're basically you're starting from the conclusion of that some crime was committed, and because a crime is committed, that's why we're going to punch through the attorney-client privilege. There should be an attorney-client privilege, but the state is saying no. We say that there's a crime here that's committed between attorney and client, so the privilege gets punched away for the crime that they're committing. And it's like, well, how do you know there's a crime? Well, we're going to look at the text, and that's how we're going to know. But before you look at the text, you're only looking at the text because you're saying there was a crime. How do you know there was a crime? Oh, well, because we said so. But there's no crime. There's no crime that's been established. How are you going to prove it? Oh, we're going to look at the text. It's like they're basically using the pierced privilege to show that they had a right to pierce the privilege, which is just backwards, stupid. You could literally say that as an argument to pierce every single freaking attorney-client privilege. Say, you just claim that there's a crime. How do you know? I don't know. We'll look through the text. What if you go through and there is nothing there? Oh, I don't know. Well, we went through it. That means there's no attorney-client privilege. So what they did to Trump was injustice, completely injustice. What the judge is doing here is he's saying, no. Attorney-client privilege applies to wherever it always has applied and will continue to apply. And it doesn't now, all of a sudden, we're going to pretend it applies in cases where he's not helping you as your attorney. But he's sitting there talking to you as a business partner. So these two are very, very, it might seem to someone who's not an attorney as being very similar to each other. But that's why I want to try and parse through that distinction so you can understand that they are not alike at all. All right, let me get through some of these other super chats here. It's been a great first month in the non-cult following. By the way, where do I hang my track jacket? I know you don't have a track jacket yet. The tracksuits are coming really soon. I keep saying that. They're not mandatory because this is not at all a type of cult, but they are coming soon. No vomiting staccato, but vomiting pollen. I was wondering if anyone was going to notice the vomiting staccato Fanny is the gift that keeps on giving. Oh, yes. I love me some Fanny. Not a cult, just the greatest late night show. Love the tracksuit. So happy when it came in the mail. We would know, and it's a cult. Joe is the great. No, lies. Thomas Burton, new member of the following. Welcome to the following. You know what it is, otherwise you wouldn't be here. In my opinion, the judge is likely even more pissed off given the previous working relationship with Fanny. Perhaps they lied to him. They took advantage of him. I also got my tracksuit today. Thanks, leader. I'm so happy for you. That's great. Yo, Joe. Your unofficial channel chronicler has been slacking. I'm back in the tunnels tomorrow, catching up on the shorts. Congratulations, by the way. I have missed you. I want you to know something. I check for you every day. Last night on the following, this is a channel called Last Night on the Following Program to try to find my best moments and clip them. And he does great work. Great work. Fanny is like Amber H. Cannot get out of her own way. All the people that go after Trump illegally and end up being the dumbest criminals need better script writers. Well said, Tara. It was mentioned on another channel that Wade's wife subpoenaed Willis in the divorce case due to recent findings in this case. This is wild. Wow. This is it's almost like they're like walking on like a floor of fly paper and they're trying to skate through unscathed so that no one should ever know they've been here. This is what I feel like. It's just like every step they're just like until they're like it's like on their knees, it's gotten on their hips. Like I can't even imagine how this. I got fly paper on my forehead now. They are just walking on fly paper. It's hilarious. 2, 4, 2 or 2 in touche. 2, 4, 2 or 2 in I don't know. Touche. Okay. I need my tracksuit to be purple. I can't promise. I can't promise. All right. Where was I at? I also want to check over here and make sure that we're good. I'm good on Rumble. Am I good on Rumble? I think I'm good on Rumble. Okay. A quick check over on locals before we finish up here. Big Boop says, first show in my new house. Welcome. Now, congrats on your new house, Big Boop. Best wishes, a happy couple, and excited for this crazy topic. It is very exciting. It is. So I just want to finish up this story here before, so I can show you the contradiction that they had. So Bradley previously testified he left the firm was asked completely covered by privilege, McAfee said on February 16th. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. McAfee stated that the only way to address the issue was to arrange a secret closed-door conference known as an in-camera session with Bradley and his counsel to determine which material Bradley possesses is protected by privilege and which is not. Basically saying, you suck at figuring what privilege is, so now you need to tell me everything so I can tell you what's privileged. That meeting happened on Monday afternoon. Today. This is what's so interesting. It happened today. And right away, he's like, we're back in court tomorrow. I'm not waiting until Friday. We're going back in court tomorrow. Former DeKalb County District Attorney Robert James stated that the problem presents Judge McAfee with a difficult challenge requiring him to balance two opposing interests, the exposure of relevant evidence and the safeguarding of a highly cherished principle of legal representation. It's not that. I disagree with DeKalb County District Attorney Robert James. Privilege is sacrosanct. I agree with you that, but figuring out where it applies is not that hard. It's really not that hard. The rules are pretty clear. Was this said to you? How is that? How, on what basis is this being said to you? How is this helping you be a better attorney for him? How is this giving you more knowledge that's necessary to help you be a better attorney? How? If he shows you a love letter he wrote to Fani Willis, is that going to make you better able to represent him in his divorce with his wife? No. If once you know that he's dating Fani Willis, if he tells you the next day, hey, I've got a date tonight with Fani Willis, is that helping you better understand how to represent him? No, it's not. It's only the first time, if anything. Not to mention that it's very murky when he first started working on his divorce case at all. Just because, Wade wants to pretend that the privilege attaches all the way back in 6 years before he got divorced. That's kind of crazy. And then it clearly doesn't apply to every conversation I had after that. So that's why I said the application can be murky. A judge can walk him through and say, it's not. And here's the thing. If you're Terrence Bradley and a judge rules that it's not privileged, he's absolved from any liability. So it doesn't really hurt him anymore at this point. If he says, I said it was privileged, judge says not, I have to listen to the judge. The Georgia Bar Association is not going to punish him for that. Right? If you can't have privilege or secret communication or protect the communication with your client, then why would they disclose everything? If they don't disclose everything, you can't give them good legal advice. Yeah, that's the point, is if they're giving legal advice. Bradley, Wade's former legal partner, previously represented him in his Cobb County divorce, may have provided evidence to support co-defendants' claims that Wade and Willis had romantic involvement earlier than they claimed in court documents. It has the potential to blow the case wide open and lead to the disqualification of both Nathan Wade and Fani Willis from the Trump RICO case in Georgia. Much more than that. I'm going to tell you something. If he has direct evidence that shows that they had a hot and heavy relationship in 2021, they've committed perjury. They seriously could be facing criminal charges. They could be facing losing their law licenses. That they purposefully perjuring, they're purposefully lying under oath in this court. They seriously could lose their law licenses. They can face legal action. I think in the state of Georgia, they're closer to going to jail than Trump is. That's how serious this situation is. I think they're closer to going to jail than Trump is right now. Melanie Heddick, love the fly paper. Awesome. They're so bad. They're such bad lawyers. I feel like they're such bad lawyers. Thank you for the very generous super chat. Appreciate that. I want a zoot suit tracksuit, please. Licking lead paint as a vaccine. Yeah, pretty much. That's what they seem to be doing. We are a cult. Joe is our leader. Congrats on the wedding. Time to move on to Jack, Letitia, or the other cases. Fanny's done. Tracksuit is on order. There's a backlog on tracksuits right now. There's a backlog on tracksuits. Should I show you where they contradict each other? You want to see them actually say things that cannot possibly both be true? Should I show it to you? I think you probably want to see this. This is the part Steve Sadow needs to see. I think he has seen it. He likely has seen it, but I want to walk you through the full ramifications here. Now, let's understand context when they're taking the stand before we look at this little bits of testimony here. Okay? Make sure I have this queued up in the right place. I think I have this in the right place. I'm either right before it or right after it. So if I'm right after, I apologize for that. But I'm going to start with Nathan Wade. Understand this. Now, Fani Willis in 2021 says that she was getting death threats at 5 o'clock in the morning. So she moved out of her house and she moves into this condo and takes over the lease of a Miss Yurdy. I think her name is Robin. I think it's Robin Yurdy. I don't remember. I think it's Robin Yurdy. It was a friend of hers that goes back decades. She takes over this condo lease in February of 2021. And that's when she moves in there. Now, we can call this the Yurdy condo. We can call it the love nest. You can call it whatever you want, because this is where the geolocations are showing that Wade pops in there 35 times. 35 times. All right. So we need to go back and look at his testimony about his coming to the apartment. Now, what's really important here that you need to understand is Robin Yurdy was the first person. Bradley came up and testified for like a minute or two, a few minutes, and there was all these different objections and privilege things. And then because Robin Yurdy was late, then Yurdy got on and they said, all right, let's push Bradley back and let's listen to Yurdy. And Yurdy was the first one to really give actual testimony, which was very damaging to Fani Willis, because she's like, yeah, Fani met him in 2019. She told me about it. A few months later, like late 2019, early 2020, she told me that they were dating. I used to see them all over each other, like lovey-dovey all over each other, hugging, kissing, stuff like that. In 2020, 2021, 2022. I don't know what she said in 2022. But basically, that she saw them acting all lovey-dovey with each other. This is after Wade had already submitted an affidavit claiming that their relationship did not begin until months after he was hired. Now, the key date he's hired is November 1st, 2021. And they claim that their relationship first began 3 or 4 months later in March or April 2022. So now you got Yurdy coming out of the gate here saying, oh, yeah, the entire 2020, basically the entire 2020 and all 2021, they were a hot item and they're all over each other in front of me. And she said at a certain point that Fani Willis took over her lease, moved into her place. Okay, this is the interesting thing here. Check this out. Let's talk about his visits. Now, the place that her condo is in an area called Hapeville. So let's hear the testimony about that, about his visit, Nathan Wade's visits to Hapeville. And pay close attention, because he knows that this Hapeville place is being basically referenced as, their little love nest. And he's trying to make it look like that's not why he was going there in 2021. Not for that at all. Let's listen to his testimony on this.
Was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
This is in 2022. In other words, was it a secret in 2022?
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay. Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, Did you tell anyone?
No,
Do you have any knowledge of whether Ms. Willis revealed it to anyone?
I have no clue.
So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
Wasn't kept secret. It was kept private.
No, and even when he's answering questions here, what's kind of sketchy is it's still private if you file forms letting the state know that you're in this relationship. They never filed these forms, period, even though they admit they ultimately took on a relationship. But I believe that this is supposed to be noticed. Now, she claims that she didn't have to because he's not working for her. That's part of what she says in her testimony. He's very clear. He's not working for me. We're about to get to where he starts talking about the Hapeville residents.
The purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly.
That has nothing to do with why you wouldn't file that form, right? That's got nothing to do with it, because you can file with the state. That's not something people would know about. I don't think that would become a public record. Plus, that's not going to help people find you in a restaurant. So you still might want to be private if you want to have private meetings. Let's imagine they did this properly, right? Imagine that they came out in 2021. Let's assume, or in 2022, whatever time it was that their relationship started, and they file the form and they say, hey, just to let you know, we're now romantically involved. Is that going to help someone find them in a restaurant? Is that going to give them more privacy or less privacy when they go to the beach? I don't think so. I don't see how that's doing that at all. It's not really even answering his question, because he starts talking about how, well, we didn't want to have gawkers or people talking about us or whatever. It's like, that's not doing anything. That's not related to the question Steve Sadow. And these questions are coming from Steve Sadow, Trump's attorney.
And I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret. It is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadow.
Yes, you were.
There's nothing secret or salacious about having a private life. Nothing.
See, he's trying to make it like, yeah, you're all invading our private life. If you follow form, that's not invasion of your private life. That's just you acting with integrity.
Suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant, did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Sadow, no.
And again, that was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Ms. Willis go to the Hapeville condo prior to your relationship starting the beginning of 2022?
So this is the key point here. Now understand this. What we did not know when we were watching this live, we did not know that he had already subpoenaed and that morning got access to the phone records, but hadn't had a chance to really go through them. His investigator, they subpoenaed them on February 9th. This hearing, this testimony is happening the morning of February 15th. At some point on February 15th, likely before this testimony comes in, based on the questions Sadow asks, they already are in possession of his phone records, but have not yet had an opportunity to really start parsing through what they mean.
Prior to having physical contact prior to having intercourse? Did we go to the Hapeville condo?
Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, or my question would be yes. Did you and Miss Willis go to the Hapeville condo prior to what I want to say November 1st of 2021?
Yes.
Okay. And the purpose for going to the Hapeville condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could have been any number of things, because at that time,
That's what I'm asking. So tell me.
yeah, could have been any number of things, because at that time, she had a friend living in that condo. Miss Yurdy lived.
Miss Yurdy at that time was living in the condo. Now, Fani Willis is living there, and he's saying that at that time, Miss Yurdy's living there too.
in that condo.
Okay.
Let's hear that one more time. This is important because this is the key part.
2021 would have been what? Or prior to November 1 of 2021?
Could have been any number of things, because at that time,
That's what I'm asking. So tell me.
yeah, could have been any number of things, because at that time, she had a friend living in that condo. Miss Yurdy lived in that condo.
Okay. Maybe it was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021, you would have gone to the Hapeville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yurdy resided there, went to visit her, maybe went to
The Hapeville condo and been there with Miss Willis,
That wasn't me.
yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yurdy resided there, went to visit her, maybe went to talk about a document that I received.
You would go to the condo
I
to
needed
talk
to
about a
see.
document that you received?
Absolutely.
Okay, go ahead.
Absolutely.
Any other reasons?
None come to mind.
None come to mind.
No, sir.
And would you say that was frequent? When I say frequent, do you think
So the reasons, let's just make sure that we lock this in. He's going there to visit her and Miss Yurdy, or to review documents. These are the two reasons he's going to the condo before 2021. Okay. And these are the reasons he's there, to hang out with Robin and Fani. I think her name is Robin, pretty sure. But Miss Yurdy and with Fani, I guess he has some sort of personal relationship with both of them, and to review documents. Okay. How often?
prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it'd be less than 10 times.
Yes.
Less than 10 times.
Phone records were to reflect that you were making phone calls from the same location as the condo before November 1st of 2021, and it was on multiple occasions. The phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong.
They'd be wrong.
Okay. Where did you live during that time period?
Such a stupid answer. When he's asking you that question, you have to know, dude's seen phone records that show you're full of crap.
Same place I live now.
Which is not in Hapeville, correct?
It is not in Hapeville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. And any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021?
And these are great questions because he's trying to pin him, lock him in here into give me all the reasons that you would be there. So, list them all off. So this way, then we could start checking phone records and see if this is consistent. Because if he was a smart liar rather than an idiot, what he would have had ready was that he has some other friend who lives in the area. So he goes to Hapeville frequently to hang out with Jim or Terrence or Derek or some chick. Doesn't matter. But some other purpose that he would be there at odd hours. You know that there's phone records. You know it. The guy just asked you, if the phone records say you're a liar, what is the reason you're going to give me to tell me that you were there? And what does this moron give him?
Let's see. The Porsche Experience is there.
Oh yeah, Porsche Experience. They're open from you can book at the Porsche Experience. They have viewing hours. You can book a session from 9 a.m. to 1 p.m. or from 1 p.m. to 5 p.m. But that's it.
Sorry?
The Porsche Experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hapeville.
He's like, there's an airport in Hapeville? Really? Really?
Yes, sir. Delta Airlines is
Okay.
headquartered there. Let's see.
Okay.
Restaurants there.
Okay. Restaurants. Now you gotta find restaurants that are open at midnight.
If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's
okay.
Okay.
So there you go. So he's been there fewer than 10 times. The reason he's there is because of he's Robin Yeardy's there, or to give off documents and phone records. If they say otherwise, the only thing he can come up with is maybe Porsche Experience, maybe restaurants, maybe I don't know. He found an airport there, or the Delta Experience. I don't know what it is. I don't know. That's what he says. Let's watch Fani Willis contradict him. Here's Steve Sadow asking her about that. I think I have to go back like 3 or 4 minutes here.
Not want to leave the house because he was particularly worried at his age about COVID. But that
At this point in the questioning, Steve Sadow is asking Fani Willis why she moved out of her house. And she said there was a safety concern. And he starts asking her, well, your father stayed behind and he's living there. If there's a safety concern, you're getting death threats. Aren't you worried for your father? That your father's still there? Isn't that, why would you leave your dad in a place that might be attacked by some crazy person? Why would you leave your dad there? That doesn't make any sense. And Fani Willis has her explanation for why it is that her dad stayed there.
that became I don't want to say I was not happy with that decision of my father's, but I can't ultimately make him leave, and he stayed there too long, in my opinion.
Okay, thank you. During that period that you left to go to the Yerty condo,
Yeah.
did any of your children stay at your house?
So I don't think that they were there at that point. Certainly my baby wasn't there.
I'm talking about this entire period. We're talking about, if I remember correctly, and you'll correct me, I'm sure, you said that you stayed there at what I would call the Yerty condo until January of 2022, correct?
Yes.
Okay,
And she's there from February of 2021 for almost a year until January of 2022.
so I'm asking you in that period, which would be February to April of 2021 until January of 22, did any of your children stay at your house?
And you don't have to yell at me. I'm able to understand.
He's not
So I would
yelling.
ask you to not yell at me. That
I was laughing when I saw this the first time. I was like, he's not even yelling. He's not yelling. He should say, please stop yelling in response. The reason I was making that point is because when on a record, she's trying to poison the record to make it sound like when you're reading the record, they're like, oh, he was crazy rude to her. So if you weren't really watching it, you're just reading it, you can't tell volume, you can't tell tone. So when she says that, it implies that he's yelling like a crazy person. You don't know if he's like, was anyone else there? Or well, was anyone else there? And you can't tell. It reads exactly the same on the transcript. So when she says, please stop yelling at me, that implies that he's screaming his head off, which is why I think it's a really funny thing for lawyers to basically say that at random times, even if people are practically whispering, because it just, anyone who reads the transcript afterwards, like, oh, wow, this person's a crazy person. It's a great way of poisoning a record if you're not a nice attorney. I don't think she's a nice attorney.
Being said, I don't actually expressly remember, but I can tell you, since I have left my home, there have been times my oldest daughter came in, but I can't tell you with certainty the time window that you've said, if they did or not. And so I don't want to speculate to that, but there was some time that my oldest daughter came back, whether it was that period or after I left the Yurdi residence, I'm not sure, okay?
Okay, so if I continue to go into more detail on this, you're not going to be able to give me an answer of whether or not, in fact, any of your children were still at the house or stayed at your house during that time period, correct?
What I can give you clarity of so that we are clear is from the time I moved out in February-ish of 2021, after I left there was a time period that my oldest daughter came back. But if you're asking me, was it in that window or after, I just don't have a recollection of that because, you know, your kids come and they go. And so I don't remember the specific time period, and I apologize for that.
Did your children ever stay with you at the Yurti condo?
Now we start getting to the Yurdi condo. Remember, why did Nathan Wade go to the Yurdi condo? 2 reasons he gave us. One was, well, that's where she was living there at the time. Yurdi was living there, right? 2 was document review. Okay, let's hear. Were your children living there with you at the Yurdi condo?
Like maybe a night.
Okay.
Like for a girls' night or something, but live with, no.
Okay. Did anyone else stay with you at the Yurti condo,
That was
including Miss Yurti?
never. Miss Yurdi never lived in the condo. She met her husband and they moved. They weren't quite married, but they moved. Nobody ever lived with me in the condo. That was
My
A
word
lonely
was, my
period.
word was stayed, not lived. Stayed with you at the condo.
I guess I don't understand the distinction, but no one ever, I think my baby, my oldest child, I think she spent one night with me, maybe my oldest and my youngest. But I think that whole time I was in that place, other than that one night, I don't think anyone ever, that was a very lonely period in my life. I don't think anyone ever spent the
Not very. Not very.
night other than maybe one night. I remember a picture of my baby sitting on the couch in that place, and I'm thinking she spent that night, but just a very lonely time in life.
Okay, now, we'll stay with the lonely theme just for a minute. Did Nathan Wade visit you at the Yurti condo from the time you moved in until he was hired on November the 1st of 2021?
So I moved out of that condo, but during that time period, I'm sure he came to visit. He came to visit. I can remember us going, I think the restaurant's Lickety Split. I can remember him picking me up, going to Lickety Split and ordering some food and coming and sitting at my table and eating. So I remember times that he visited me at that condo. Yes.
Okay, could you give us an approximation of how many times Mr. Wade visited you at the condo between the time you moved in and prior to November 1 of 2020?
I don't think often, but I don't want to speculate.
2021.
Can we say more than 5, more than 10?
I'm gonna tell you the problem I'm having here. Let's say more than 10, but I'm not sure that that's even accurate. He certainly has come and picked me up, gone and grabbed some food to eat. I don't remember him being in that condo a lot.
Okay, that's
I'm sorry. You want a number, and what I don't want to do.
giving me your
is to
current
mess-
and best recollection is all I'm asking for.
That's all I can give you, sir.
How many times did any of the prosecution team, how many times did
Just
Anna
so great.
Cross come to that
So
condo between the time you moved in and November 1st of 2021?
I don't think Anna's ever been to that condo.
What about any other prosecutor that's involved in the prosecution of this case?
I don't think any of them have.
no.
Just Mr. Wade.
That's correct, sir.
But it was a lonely time.
Oh my God, that 2021.
It was a lonely time.
I have a lot of guilt about this time period in my life. Let me tell you why. But yes, it was a lonely time.
Okay.
I was very appreciative to the citizens for giving me this responsibility and this duty. But what I very, very quickly learned is that this is a very isolating job. And 2021 was a lonely time. I turned 50 in 2021. That's probably one of the worst birthdays I've ever had. I spent it alone. So I have a clear recollection of 2021 being lonely.
Did Mr. Wade ever visit you at the condo in the time period I'm talking about prior to November of 2021 when Miss Yerty was at the condo?
So Miss Yurdy and me, when we didn't share the condo at the same time,
So the answer would be no.
but we never stayed there together. So it's an
Oh, I'm saying-
impossibility.
It's an impossibility.
Yeah.
Okay.
Now, Miss Yurdy, because we need to get clarification on this. Miss Yurdy stayed in that place. There may have been a time that me and Mr. Wade visited, like went and saw Miss Yurdy, but me and Miss Yurdy never lived there together. Just so we're clear.
Well, maybe that was clear, but I'm going to have to try again.
Okay.
Was Miss Yerty still living in the condo when you moved in?
Not a day.
Okay. So
That
what
was
I'm
another
talking,
misrepresentation in this.
Oh yeah.
We
Apparently it's a misrepresentation from Nathan Wade. Because that's what Nathan Wade said. That's what I'm saying. That's what I'm saying. These two things don't add up. This doesn't add up. And Steve Sadow is like very confused. He's very confused. He's like, what they're saying here isn't really adding up.
Never lived together. I never lived with Miss Yurdy.
my question though, I'm trying to understand
Okay.
that after you moved in to the condo, Miss Yerty she was out of the condo, right?
She got a house.
That's all I'm asking. She's not in the condo.
We never stay, Miss Yurty and I never stay a day together in the condo. All of her stuff was out of the condo and all my stuff, some of my stuff, not all of it obviously, was moved into the condo. So we never stayed there together. No, sir.
All right. So when I ask you about Mr. Wade visiting the condo,
Yes,
when you were staying there,
yes.
Miss Yerty wasn't staying there,
She
correct?
ain't
That would
there.
be correct, yes.
She wouldn't be at the condo, correct?
No, she would not have been.
It would be you and Mr. Wade alone at the condo, correct?
Yes,
That is, there weren't any other witnesses to Mr. Wade and you at the condo, correct?
yes.
No security, none of your security details.
Just the
Yeah,
two of
he said It
you.
was just her and Mr. Wade.
You made your point, Mr. Sadow.
So there you go. There you go. So now you tell me. He's saying I'm coming to visit there, hang out with Fanny and Miss Yurdy. She's like, no, sorry, Bob. That never happened. Now, to me, these two testimonies they don't really blend. He's saying, I came there to see Yurdy. She's like, no, he didn't. That's not true. Now, let's speculate what's going through their minds. One of them here is not telling the truth. One of them's not telling the truth. So let's speculate what's going through their minds. Why would they be saying such a thing? Why would they be like lying like this? They're contradicting each other facially here, right? He's saying, I'm coming there to visit Yurdy. She's living at the time. She's living with him. Fanny's saying, no. She's not living there. She's never there. Just two of us. No one else there. Not security, nobody. Just me and him. That's it. So someone's lying. Somebody's lying here. Why? Why are they lying? I mean, there's only one reason for Nathan to be lying. The reason you could think for Nathan to be lying is to make it look less salacious, right? I'm going to pretend that someone else is there. If I pretend someone else is there, so it's less likely anyone's going to suspect that I'm doing something, a little bangy with Fanny here. Because Robin Yurdy's there. I'm there to hang out with the two of them. So that would be a reason for him to pretend that Miss Yurdy was there, even if she wasn't. In which case, Fanny's telling the truth, and Nathan is lying in order to make the relationship look less physical. Or perhaps he's telling the truth, and Yurdy was there. But Fanny knows that Yurdy had already testified that she was watching them, and every time they're seeing them, the two of them look like a couple of high school kids crawling all over each other on the couch. And she's like, she doesn't know that. She wasn't even there. So she would be lying he would be lying so that they can hide, he's trying to hide the relationship, or she's lying because she's trying to hide the relationship and she doesn't want everyone to believe Miss Yeardy and say she has no way of knowing how they acted around each other because she didn't see them around each other. But either way, one of them's lying, if not both of them, for the purposes of trying to hide just how hot and heavy Fani and Nathan were. That's the only possible explanation, because these two testimonies contradict each other. She's either there, or Yeardy is either there or she ain't. And according to Wade, she's there. She's living there. She's there. Oh yeah, I'm going there. You have to realize she's living there, and I'm going there. I'm visiting with Miss Yeardy. And they got Fani over here saying, no. She's gone. She moved on. She ain't around anywhere. She couldn't see us. She had no idea what type of relationship we had. She couldn't see anything. She was never around. So that's what Steve Sadow really needs to hit on. I hope he sees that. I think he has, because look, he's the one. He wasn't the one who was doing the primary direct of either Nathan or Fani. Ashley Merchant's the one who did primary direct of each of them. He certainly seemed far more efficient and far more direct and pointed and he had direction with where he was going, seemingly a lot stronger than what Ashley Merchant had. And he's the same person who asked the same line of questions and was asking specifically about phone records and why you're there and who's there and what's going on and who would be a witness to what was happening in there, how many times you've been there. And he's asking these questions to Nathan, and he's asking these questions to Fani. So I'm telling you right now, I am very, very confident that whenever closing arguments happen, and they may be tomorrow, in which case I'll be streaming it tomorrow, or they may be sometime in the future, in which case I'll be streaming it then. But I am confident that Steve Sadow, very smart, shrewd attorney, saw this direct conflict in their testimony, where one of them, at the very least, if not both of them, were lying about what the situation and status of Yeardy was, because they felt that that would be a better way to mask their relationship that was going on in 2021. That's the contradiction that I wanted to share with you all. I think you all seen it. Anyone disagree that that was very direct contradiction as to whether or not Yeardy's there? So I wanted to share that with all of you. Now I also want to get into his reply. Before we do that, he brought an application to the court to have testimony, to have the phone records admitted as evidence. We need to look through, and the state, yesterday we went through the state's opposition saying, no, this is a Daubert violation. This isn't science, and you try and bring in an expert witness, and you need to have an expert witness, and he's not an expert, he's not qualified, and there's all sorts of different reasons that it's too late, they had to do it earlier, they can't do it now, et cetera, et cetera. It's too late, and he's not qualified, and it's not scientific. So we're going to see what Steve Sadow, that attorney we were just watching now, his response is. We're going to go through his response momentarily. First, let me get through paying some bills here. My name is Robert Paulson. It was 134. Thank you, sir. You're still 134 to me. You're alive and kicking. The month of March has the most observed causes of someone's concern. Come on, Joe. Jeannie Jiwi cultist. I don't know what Jiwi means. The cover-up is the worse than the crime. It is. It is. The fact that they're lying, it's much, much worse. Given the alleged shenanigans and shortcuts involved in the Trump investigation, could Fani's entire prosecutorial record be subject to review? Unlikely. I think that's unlikely. That's very unlikely. I wouldn't expect any other defendants to be beneficiaries of this. Could happen, but I'd be surprised. If anyone admits they were dating when the second contract was signed, why is that one being taken so lightly? So I think the reason is because they want to say that the motivation is a very good question. It's a very good question. I think you sort of have to look at it from what's the motivation for them hiring and going forward with this? The reason they're motivated to do it is because they feel like, is it in the interest of justice, or is it because she's trying to line her boyfriend's pockets? Well, if he's not her boyfriend at the time that he's first hired, and then the case continues for more than a year, so you're going to keep the same guy on there, it sort of washes away a claim that her motivation for giving the second contract was to line her boyfriend's pockets, because she was doing it even when it wasn't that this prosecution is about lining Wade's pockets, because she gave him the money even when they weren't dating. So now to continue onward, obviously he has to continue onward. They're not going to just switch ships because they start a romantic relationship. So that's why I think and no one's assuming that, she's not benefiting from it, which arguably she was, don't get me wrong. But it's like you sort of can understand that they're not going to be forced to well, now that you're in a relationship, he can't be special prosecutor anymore. That doesn't seem, that seems, the question is, was this prosecution motivated by Fani looking to enrich Wade? But just continuing the prosecution onward feels less like a miscarriage of justice. Is Trump replied, to use an analogy, I can understand that the science behind a radar gun needs an expert, but this is what the trained use of radar gun says when measured by the radar gun. I haven't gone through his reply yet. We're going to. Imagine having TDS so bad, and instead of dropping this ridiculous case, you and your ego decide it's smarter to burn down your whole law career. I think that they're married here. I think they're locked in here, Robin. I really do. I'm sure they're having deep regrets. I'm sure they're having deep regrets at this point. My income is private, but I still have to file 1040. Yep. If he didn't file because he didn't want people interrupting Fani and him, and they were still being interrupted, the rationale for not filing didn't work to keep the relationship private. You have to imagine. You have to imagine. He's not a very smart man. I'm not a smart man. Trump attacks DEI corruption, lights a Cuban and laments. I love it when a plan comes together. Cute theme tune. Bum, 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 bum. Bum, ba-dum, bum, ba-dum, bum. Is the Georgia Election Board after Fani? There is an investigation. It's supposed to be proceeding on March 7th. I'm going to be live streaming it. Or he left his phone and someone else used it. Yeah. And then brought it back home at 4 o'clock in the morning. Could be. Sorry, I can't hear over the sound of her eyebrows. If he wasn't working for her in 2021, what documents was he dropping off? There are so many lies and contradictions. They should be ashamed. Yeah, these are good questions too. I had the same question also. Like, I don't know, maybe there's documents like initial research before the hiring of special prosecutor. I don't know. Thank you for the super chat, Jacob Kedra. Isn't part of this that they created this novel case with political defendants to justify hiring Wade? Wasn't Wade helping create it? I'm not sure I understand. Isn't part of this that they may have created this novel case with political defendants to justify hiring Wade? Wasn't Wade helping create it? At which point are you asking? I'm not sure what you're asking. At which point was he helping create it? You mean back in 2021? In early 2021? I'm not sure what you're asking, Project Com. All right. We need to get to the reply. Let's do that. Let's do that presently. Let's do the reply. While you're here, if you could please like and subscribe, I would really appreciate it. Like and subscribe. There's 3,500 of you watching on YouTube and on Rumble. There's another 710 of you. So yeah, I would appreciate if you all can just hit that like and subscribe. It would be very, very, very meaningful to me. My therapist will be like, oh, finally, he can start feeling some love. So I would be much obliged if you could just hit the like and subscribe while you're here. Thank you. And also turn on notifications, because otherwise YouTube will never let you know. They'll never let you know. You'll never find me again. This relationship will be so fleeting. I'm going to feel all alone. He was on transition team is why he was at condo will be the next reason used. Yeah. I don't know. Maybe. I don't know. They should have said that. The entire case was answering the question in 2021. Who can we prosecute to justify hiring an outside firm that Wade owns and gets a large budget? Yeah. So I agree with you. That's what the claim of the defense is. That's exactly what their claim is. It's ironic because to me, if you would have asked me what their primary motivation is, I don't think it's to get Wade rich. I don't think it's to get Wade rich. I think primary motivation is the publicity of being the ones who get to hang Trump. seems like such a bigger carrot to me. It's so funny to me that the judge is so fixated on this romantic relationship, whereas which creates a far more salacious story. But if you ask me, no, this was a matter of they don't care about justice at all. They just care about going after this fish so they can get their names in papers and basically become governor, or have and also probably they hate Trump, but it's like they feel like it's politically convenient to go after him. To me, that carrot is so much greater than the couple $100,000 that he's going to make. Have you seen 60 Minutes segments with Wisconsin elector Andrew Hitt? I have not seen that. Do I need to? Is that something I need to see? All right, let's get to his reply. It's not that long. It's only 11 pages, so this shouldn't take very long. All right. So, in case you're unaware, Steve Sadow submitted an application to the court allowing him to have the record supplemented by adding in various phone records, and specifically an affidavit from, I believe his name is Scott Middlestat, but we'll probably have his name. Something Middlestat. They want to have Middlestat's affidavit become part of the record, where he basically testifies that on at least 2 occasions there were these very late night meetings. One of them was in November. One of them was in September 21st into 22nd, 2021, which is before he was hired. Another one on November 29th, where and aside from the fact that there was 2,000 phone calls in 2021 and 12,000 text messages. 12,000 text messages. Unbelievable. All right. So none of this is officially part of the record. When he submitted that, the court, the state was like, no, you can't take it in, judge. You can't take it in. Here's the reply from Steve Sadow. Affiant Middleton is not being offered as an expert witness, so neither the court's standing discovery order nor Daubert applies. So one of the objections that they made is, if you're going to try bringing in an expert witness, so you have to give notice to the other side, there has to be 7-day notice, and there has to be, and also it has to be past Daubert. Daubert is a Supreme Court case which says what are the yardsticks for being scientifically sufficiently scientifically valid that it can come before the courts. As a general rule, the Supreme Court has said our court system should not be allowing in what is widely regarded as junk science, because that's not going to help us know things better. It'll just confuse the jury or the court if the court is the finder of fact. So, if someone comes in here and says, I'm a scientist and I can tell you that if a person snaps their fingers 14 times every day, that will cure them of their breast cancer. And here's this, and I have science to believe it. And everyone looks at the person like they're a lunatic. So we don't want that person coming in and influencing the trier of fact, say, oh, that's why he was snapping his fingers and gave up chemo, or she was probably in the case I gave. So not to assume anybody's gender, even though we should always assume the gender. Always assume the gender. Always assume the gender. So that being the case, that's what Daubert's all about. What are the yardsticks that we use in order to show that this science is sufficiently reliable that it can be entered as evidence? Affiant Middlestat is not being offered as an expert witness, so neither the court's standing discovery order, which their standing discovery order is that you have to let the other side know and then have a whole summary before and give them advance notice, nor Daubert applies. The state protests that the defense is somehow not entitled to represent expert testimony regarding the cell site location information, CSLI, as they allege that the defense failed to comply with this court's standing discovery order that mandates prior notice to the opposing party of a party's intention to introduce expert testimony, and because they claim the defense does not pre-clear the evidence through the process of a Daubert hearing. However, neither of those preconditions apply here, because the CSLI information that the defense intends to introduce through the testimony of Middlestat is not being offered through expert testimony, and Middlestat will not be offering any opinion testimony. There's no opinions coming from Middlestat. An expert witness, any witness who comes and testifies in any capacity before the state is stating fact. You can only attest to fact that you yourself has seen. The exception to that is an expert. An expert can say, these set of facts lead me to a certain opinion. And this is my professional opinion. Before a person can give that sort of testimony, the court must first qualify them as an expert in the area that he or she intends to opine. So, when a person gets qualified as an expert in X area, that gives them the ability to break the normal standard rules of testifying about that which you have seen, and all of a sudden just start walking off and saying, in my professional opinion, I think XYZ. If you are qualified as an expert cardiologist, you cannot start giving your opinion as to how good a car is. Right? It has to be, you can't even give your expert opinion about whether or not a foot required surgery, because you're a cardiologist, you're not a podiatrist. You're only qualified, and the area you're qualified in, that enables you to give your expert opinion. So what they're saying is he's not coming in here as an expert witness. He's not giving his opinion, and therefore there's none of these qualifications. He will be summarizing the data that was produced by AT&T in response to the lawfully issued subpoena, as well as factual information that he acquired regarding cell site locations. First, the 11th Circuit has held that precisely the type of evidence that Middlestat will offer does not require the testimony of an expert witness. United States versus Ransford, 749, F3rd, 914. 937, 938, 11th Circuit, 2014. Now, is this governing? Is this governing on this court? Here we have an 11th Circuit, which Georgia is situated in the 11th Circuit, 11th Circuit decision, which says that exactly this type of case, it's not called expert witness. You can't just say this is expert witness and therefore now you have to follow all the regulations of admitting expert witness, because the 11th Circuit has said it's not. Now, this is not perhaps mandatory for McAfee to say that this is the law in Georgia, but it's highly influential. Highly influential, as I'll explain soon. Let's look at what happened in Ransford. In Ransford, the government presented a witness from a cell phone service provider who explained how cell towers work, how evidence preserved in the company's computer can show what tower cell phone was pinging at a certain time. A police detective also testified how cell phones ping off towers. The Ransford court explained why the company's witness was permitted to offer testimony that was neither expert testimony nor opinion testimony about the cell towers and location of the phones. And this is what the court said. Here, Dikovitsky, the company witness, explained how cell phone towers record pings from each cell phone number and how he mapped the cell phone tower locations for each phone call for numerous exhibits. Hannah does not point to any statements of opinion by Dikovitsky. Is that really his name, Dikovitsky? Dikovitsky? All right. Hannah does not point to any statements of opinion by Dikovitsky, and we do not find any in the record. Hannah does not contend that this testimony was beyond the witness's personal knowledge or that Dikovitsky should have been treated as an expert witness. We rely on United States versus Hammaker, where we held a financial expert's testimony matching billing records to payroll and accounting records were factual statements. That's not a statement of opinion. You're just saying these match. It's not like it was an opinion. Do they match? Do they not? You're saying this is the same thing. You don't need, that's something that you just have someone go spend the time to look through the work. You don't need to be an expert to do that. The testimony did not require expertise because it was a summary of financial records the witness reviewed and an explanation of how the summary was calculated. Moreover, there is no suggestion that the information presented was inaccurate or prejudicial to Hannah. Since the witness did not offer any opinions, the district court could not have erred in admitting the testimony under Rule 701. So, the holding in Ransford dictates the result in this case. Questions about the interpretation of the Georgia Evidence Code rely on 11th Circuit precedents, absent any contrary authority from the Georgia appellate courts. There is no contrary authority from any Georgia appellate court. Wow. See, I like this attorney. I really like this attorney. Damn, I like this attorney. I was about to go down a road and say, I don't know if this is going to really hold the day. And then he writes this sentence. Let me explain to you what I was going to say. And then I'm going to explain to you how Steve Sadow said, I have a feeling that Joe Neerman may be doing a podcast and going through this. And he's going to critique me and say, well, that's not necessarily binding. But I'm explaining to you why it is binding. Now, so before I go any further, let me explain to you what was going through my head, the concern that I have, and how Steve Sadow said, no, Joe, don't worry about that. Joe, don't. And by the way, Judge McAfee also, don't worry about that, in case Judge McAfee had a similar thought to what I had, which is this. In this case, we'll come back to this. Don't worry, we're coming back for sure. But I just need to walk you through the way law operates. This is a state case, right? It's in Georgia State Court. He's citing a case from the 11th Circuit, that is federal court, for the jurisdiction where Georgia is located. Okay? So what the Georgia federal court is doing is they're interpreting how Georgia law operates. Now, if the Georgia Supreme Court or Georgia Appellate Court issues a decision, it's a higher court in the same chain, meaning you have your state chain and then you have your federal chain, right? So state chain, so you have the appellate court in Georgia, and then you have probably what's called the Supreme Court of Georgia. I'm not sure what they call it. They have different names in different states, but you have your tiers that work in one form of a cake, and then you have that's higher, and whoever's higher on the tier, whatever they say the law is, that dictates that the lower courts must follow that. If you're not in that tier, if they're not above you in that tier, they're on a whole different plane where this is now federal court, and then you have the federal district court level, and then you have the circuit court level, and then you have the Supreme Court. So the Supreme Court is going to be governing everyone. But the circuit court of federal doesn't really govern what you must follow if you're a state court judge in Georgia. So I had concerns. I was like, okay, so this is an 11th Circuit case. It's nice that that's in the same jurisdiction. It's better than if it was, a Second Circuit case, which is not, a whole different state. But that's not really telling us what the law must be that McAfee must follow. That's called not precedential. Precedential means you must follow. It's a precedent that you have to walk in those footsteps. It's called influential. So when you're trying to figure out which way to walk, it's pushing you towards this way, but you could ignore the push and go a different way. So I said, okay, this is a great case. It's right on point, perfect on point, but it's not precedential. It's only influential. And McAfee could say, that's what the circuit court said, but I disagree with them, and I'm going to go a different way. That was my concern. Steve Sadow, sharp tool that he is, saw that. And rather than just leaving it at the influential level, he says, no. According to questions about interpretation of the Georgia Evidence Code, they rely on 11th Circuit precedents absent any contrary authority from Georgia appellate courts. What this means is if the Georgia appellate court hasn't weighed in on this issue, then what the circuit court rules becomes precedent for you in the state courts. What's your citation? And that since there's no contrary authority from any Georgia appellate court, you don't have any direction as to what to do. You can't just decide, I'm going to ignore the circuit court. You must follow what the circuit court said. I really like Steve Sadow. I'm glad he's on our side. Here's his evidence of that. This now is not just influential but precedential. We have held that based on the preamble in the act adopting the new evidence code, if a rule in the new evidence code is materially identical to a federal rule of evidence, we look to decisions of the federal appellate courts construing and applying the federal rules, especially the decision of the United States Supreme Court and the 11th Circuit, for guidance. Moreover, the reliability of such evidence is so clear that a Daubert hearing would not be necessary. There you go. Beautiful. 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 He's a good attorney. This guy Sadow is a good attorney. Whew. So he's basically saying this is not expert testimony. It's really compilation testimony where the guy's testing to, I went through all of this and I've seen these records and they match up. That's not an expert, and it's not qualified as an expert. And therefore all you're complaining that this is expert testimony is to no avail, because the 11th Circuit said that the state is wrong on this. Second, there's no clear authority that cell tower evidence linking a particular phone with a particular cell phone tower at any particular time can be established with the cell phone records without any witness testifying. How would we do it without having a witness testify? In U.S. v. Sanchez, the 11th Circuit approved the use of a business records exception to omit cell phone tower records that documented the tower nearest the cell phone when a phone call was placed by that phone, as well as the number that was called. The government was permitted to later call a detective to testify only as a summary witness regarding what the record showed. That's what you do. You have someone come in and explain what the records show. Otherwise, we just have a bunch of pieces of paper and then no one knows what it means. You need someone to come in and tell you what it says. Georgia courts, both before and after the new evidence code was enacted in 2013, have also approved the use of business record exception to omit evidence of a company's records to show the location of a cell phone in relation to a cell tower. Third, so this is what the government does all the time. This is what they do. They're full of crap when they're saying, oh, they can't bring this guy in here. They're full of crap. This happens all the time. Third, the introduction of computer-generated evidence similar to CSLI has also been approved without the need for expert testimony. In a recent Fifth Circuit decision, the court held that expert testimony is not required to introduce information obtained from a celebrite extraction from a cell phone. A trained technician who testifies that he operated the apparatus properly can explain what he did and the results obtained without being able to explain how the celebrite extraction works. Here, Middlestat used Cellhawk instead of Celebrite. His testimony will mirror the testimony offered in Georgia courts and courts throughout the country. When one uses a cell phone, either by texting or calling, receiving a call, or by simply having a cell phone on so it's constantly pinging, a cell tower nearby will receive and record the ping. The evidence simply shows the approximate location of the cell phones based on all nearby cell towers. Middlestat's testimony will be precisely what he described in his affidavit. Most importantly, that on September 11th, 2021, and this is what they don't want on the record, because this destroys Fani and Nathan. On September 11th, 2021, notwithstanding their swearing in that they only had a relationship that began in March of 2022, but no, 5 months earlier, 6 months earlier, Mr. Wade's phone left the Doraville area and arrived within the geofence located at the Dogwood address, Fanny's house, Fanny's condo, at 10:45 p.m. Phone remained there until September 12th at 3:28 a.m., at which time the phone traveled directly to towers located in East Cobb, consistent with his routine pinging at his residence in that area. Phone arrived in East Cobb at approximately 4:05 a.m. and records demonstrate he sent a text at 4:20 a.m. to Miss Willis. Don't worry, honey, I'm home. The reason that the text at 4:20 is because it's like he's leaving from her place. In case he tries saying I wasn't at her house, it's like, oh yeah, you just haven't sent a text message. You're at someone at some neighbor's house. Just haven't sent a text message to her 15 minutes after you got home. Woo! Also, he's going to testify on November 29, 2021. Wade's phone was pinging in the East Cobb Towers near his residence and following a call from Miss Willis, more accurately from Miss Willis's phone, at 11:32. While the call continued, his phone left the East Cobb area just after midnight, arrived within the geofence located Dogwood address at 12:43 a.m. on November 3rd, 2021. Phone remained there till 4:55 in the morning. 4 hours and 12 minutes. That's how long Nathan Wade lasted. He will offer no opinion. He will not testify as an expert, but only as a summary witness explaining exactly what the records show. Prosecution will surely point out that nobody knows what was happening in the house between midnight 3:28 a.m. and September 12th, or between midnight and 5 a.m. on November 30th. Everyone's going to say, we know that they're going to say, you don't know what was happening. You don't know. You don't know. Middlestat does not claim to know. He's not going to tell you that they were doing, that they were in flagrante delicto. He's not going to say that. He's not going to draw you stick figures. He's not going to bring a video. He's not going to give you sound effects of dogs barking and cats shrieking in terror. That's not what Middlestat's going to do. He's not going to come in here and start showing you a heat map showing their heat. That's not what's going to happen. You can't tell you what they were doing. We're only left to speculate as to what they were doing. You, the judge, can sit there and say, does this have the appearance of impropriety? And if you come to a conclusion, you might come to a conclusion, there's no appearance of impropriety, but we don't think you're going to come to that conclusion. So he's not going to tell you. He's not going to tell you what yoga positions Fani prefers. He's not going to tell you what costumes they may have been dressed in. He's not going to be telling you whether Fani's interior decor includes a waterbed, what rooms they were in. He's not going to talk about fluids. He's not going to talk about any of that stuff. All he's going to be talking about is where he was and from what time to what time. Neither does President Trump or any other defendant in this case. Middlestat doesn't claim to know. Trump doesn't know. Only two people know. They're certainly the ones who should testify and say exactly what was happening on those occasions. So nobody will complain about improper speculation or improper efforts to distort the truth or nefarious contacts with the media. We'd love to have them get on the stand again. They can take the stand again. Start swearing about how hard they were working, slaving away, working on their motions, We had to finish. We were sweating through the night that night. All we've heard from Wade and Willis so far has been that they did not have a romantic relationship until 2022. Yet it is highly significant that the state's response did not even attempt to challenge the CSLI evidence regarding September 11, 12, 2021, November 29, 30, 2021. They didn't once say it's an error, it's a lie, it's manufactured, it's fiction, it's complete. It's completely slanderous, libelous. Defense business record CSI evidence is admissible. Middlestat stands ready to testify as reflected in his affidavit. 2. Now let me pause here and pay some bills because I do have bills to pay. Wade was on Fannie's taint detail. LOL. Someone had to say it. It gets even worse. See Wade's divorce financials. I'm not sure where to dig that up right now. It's an interesting thing to try and check out. Maybe for tomorrow. Thank you. Milestone, Shep Nachas. We need a 2-minute break. How about a quick Vart? What he's saying is, congratulations. You should savor the enjoyment of watching your of being proud of your kids, and I should give you a quick word on Torah. That's what he's saying here. I think this was a 2-minute break. This was at least, it wasn't maybe a full 2 minutes, but it was close to it. So I got busy night tonight. You see, the story I broke on Friday. Delaware Superior Court ruled early voting and permanent absentee status unconstitutional Ooh, even got a statement from plaintiff's counsel on my ex. Opinion was released today. I will try to check that out for tomorrow. Thank you. Thank you. Good job, you. Imagine the CSLI is a massive Excel spreadsheet. The investigators filtered out all the lines that did not meet criteria. Attorneys will argue meaning. Yep, that's a perfect way to explain it. Thank you. Anna P. Defendant Fani is prosecuting, not related to this case, are taking notes on how to argue against cell data in their own case. They'll quote the DA herself. Yeah, seriously. But I don't. I'll tell you right now. I think that Sadow is blowing them up with this reply. This reply is it's pretty strong. Pretty strong reply. Dogwood Ash be renamed Dogwood. I like that too. DA HR complaints negatively correlated to. That's what she was doing. She was handling HR. On the stand, Fani said Wade was mistaken about Robin living in the condo while Fani did. Doesn't that highlight that she watched Wade's testimony? I didn't see her say that. I don't remember her saying that. I don't remember that at all. That is weird. That is very weird. She claimed it was a lie that other people were saying that was not true. That's what I played here. We went through that portion of her testimony. I don't know, maybe it came up later. CSLI evidence is admissible as extrinsic impeachment and substantive relevant evidence. State argues that introducing the CSLI, so this is something someone asked this question yesterday, even if it's not normally admissible, what about purposes of impeachment? And we are more open about allowing evidence for purposes of impeachment. So let's hear Steve Sadow's argument about that. State argues that introducing the CSLI evidence amounts to improper extrinsic impeachment evidence under OCGA 246608. This is simply incorrect. It is true that Rule 608B limits extrinsic evidence when the primary evidence is nothing other than evidence that is offered to prove a witness's lack of credibility based on some prior bad act. So prior bad acts is like, you want to say, you shouldn't listen to him. He's a lecher. Don't listen to him. He grows his fingernails far too long. Don't listen to him. He smells like sponge cake. Yeah. So that prior bad acts, and he was caught cheating on his geometry test in 10th grade. Yeah, all that stuff. That's where we're going to be. We're not going to allow you to impeach after the fact. That's your prior bad act. But the CSLI evidence is not being offered for the purpose of showing a prior bad act that impeached the witness's credibility. Thus, the prohibition on extrinsic evidence has no applicability here. Instead, the rule that applies is OCGA 24.6-621, which provides, in the broadest terms, that a party is entitled to offer evidence that contradicts the testimony of a witness. And this is directly contradicting their testimony. When you're coming out here and saying that we had no relationship, the witnesses in this case, both Wade and Willis, testify that their romantic relations did not begin until March or April 2022, and that they had never spent the night together prior to the spring of 2022. The evidence offered by defense to refute this testimony, the CSLI, is admissible pursuant to 24.6-621. And this is where they're really effed. This is where Fani is effed. Fani is completely effed. I agree with him. This is like, how the hell can you say that this is not admissible for purposes of impeachment? And they're going to have a very hard time keeping this out. Very hard time. This is, if the judge agrees with the state, this is the sort of thing which is reversible error on appeal. The breadth of 24.621 cannot be overstated, meaning it's supposed to be liberally interpreted to allow in the evidence. Impeachment by disproving facts testified to by a witness need not occur on cross-examination of the witness. If the witness testifies to a certain fact, the opposing party may impeach the witness simply by calling another witness who offers contrary testimony about that fact. Impeachment may also be achieved simply through the introduction of a photograph. In Kelly v. State, the defendant testified that he never walked around the house nude. Opposing parties permitted to impeach his testimony by offering a nude photograph of the defendant in his house. Similarly, in Bowen and Bowen, during the punitive damages phase of a trial, construction company witness expressed remorse for his company's conduct. Plaintiff was permitted to introduce a letter written by the company threatening to sue the plaintiff for abusive litigation to impeach the witness. Is that impeaching? Oh, so you're saying you didn't really feel bad about it. The impeaching testimony may simply reveal the witness's version of events is less likely to be true. Doesn't have to say that it's directly that he stayed overnight. It's just showing less likely to be true. So it's less likely to be true than when they say they were not romantically involved. Do you think it's any less likely to be true when you see evidence that he was there at 3 o'clock in the morning? Impeaching testimony may simply reveal a witness version of events less likely to be true, as illustrated in the case of Goodwin v. State. Defendant was charged with aggravated assault with intent to commit rape. He offered a hospital record of the victim that revealed she had cocaine in her system. The Court of Appeals held that this impeaching evidence should have been admitted because the evidence supported the defendant's version that the victim was the aggressor. Does that mean because she had cocaine, she definitely was the aggressor? No. But the point is, it leads one to think perhaps she was because she was high on cocaine. So, in short, the impeachment CSLI evidence can be introduced simply by offering the CSLI records that demonstrate that Willis and Wade spent 2 nights together on dates that contradict their version of events concerning the inception of their romantic relationship, and in contrast to their testimony that they never spent the night together at the Hapeville condominium. The defense does not propose that the court compromise by simply admitting the records into evidence pursuant to 24-6-621. The preferable method would be to allow Middlestat to testify and be subject to cross-examination by the state. This way they can say, do you know what you're talking about? If they think that he's full of crap, you can try and show that. Sadow is so good at this. CSLI evidence is also admissible as relevant substantive evidence tending to show the close interrelationship between Wade and Willis during a time period that D.A. Willis was living at the Yardley condo, April 20th to November 30th, 2021, keeping in mind that Wade was hired November 1st, 2021, and both testified there was no romantic relationship until 2022. The breadth of 24-6-2021 is compatible with the basic philosophy of the evidence code, which codifies the liberal definition of relevance. As defined in OCGA 24-401, the term relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Given the testimony of Wayne Willis that they never spent the night together at Hapeville condominium, the evidence, actual record evidence, not just an opinion or speculation, actual record evidence that proves that while talking on the phone with D.A. Willis, Wade drove from near his house to a location near her condo, if not exactly to her condo, at midnight, wherein he then remained for 5 hours, not once, but twice in 2 months, qualifies as relevant evidence, if not presumptive proof of the fact that they did spend the night together on those 2 occasions at the Hapeville condominium. Look, maybe he was sitting in his car outside her house the whole time. Let them come and say that. Let them come in and say that. And to be clear, presumptive proof is not required as a precondition to the introduction of evidence to prove a point. Evidence is relevant pursuant to 24-4-401 when it tends to make a fact that is of consequence more likely. We don't have to prove that he actually went into the house. We just make you think, what do you think happened here? Cell phone records show that they were talking on the phone and then ended up at a location near or at her condominium for 5 hours makes more than just one fact more likely than not. The facts are they spent the night together on those 2 occasions. The romance began before Wade was hired. One more fact is also more likely than true than not. Neither of them testified truthfully at the hearing on February 15th. Whoa. Strong conclusion here, which I like. One more fact is also more likely true than not. Then neither of them were telling the truth on the stand. Powerful. Bomb. I'm going to give, this is for you, Steve Sadow. Just for that closing sentence here. One more fact is almost more likely true than not. Neither of them testified truthfully at the hearing on February 15th. I'm going to give him another one. I'll tell you right now, I don't see how they're going to stay in. I think they're getting bounced out. I think they're getting bounced out. I think McAfee becomes a joke if he lets him stay in. Wherefore, President Trump respectfully requests the court rule CSLA evidence is admissible, permit the defense to call Middlestad as a witness, testify the CSLI, and his use of software Cellhawk as reflected in his affidavit, and admits exhibits A through C attached to his affidavit. Wow. Wow. Excellent, excellent, excellent work. Excellent work. So good. So good. Must suck to be Fani Willis right now. I am streaming at 2 a.m. tomorrow, 2 p.m. tomorrow. Bradley is testifying. I am streaming. I hope to see you. I haven't seen you in forever, CA Human. It's like you lost my number or something. I was like, "Where's this guy been? I haven't seen the California Human, and I don't even know." When I met you, you was like just a grape. You're a raisin now. You're gone. I don't even know. That was terrible. I have missed seeing you hang around. Everything you see, you haven't stick out because you picked like the thing with this cute little kid singing on a turtle there. So it's like so your chats stick out. Anyway, it's good to see you. I will be streaming at 2 p.m. God willing tomorrow. So yes, I'm not missing a freaking second. Not 1 second. I'm gonna start 1:45. In fact, I'm gonna do this. Oh my God, I want to even think of this. I'm going to redirect this stream to that stream. My God. Can I do it? Will that work? Oh my God. First, let me redirect you all over there. You don't have to like go anywhere. Don't go nowhere. I gotta go into my YouTube studio. I have to change the time here. Change the time. I'm going to show you what I got going on here. Originally, we all thought it was going to be today. This is. See, I'm going to show you what I got going on here. Make this a little bigger for you. I had to make private this thing that I originally had set to go up on Monday because then we saw it's not happening on Monday. But I already preset this up. So now I had to move this over to private. So I'm going to change the date and time on this. Let's edit this. I'm going to change time. Where's date and time? It's a little smaller. Date and time. Here we go. It's going to be February 27th. We'll make it 1:45 p.m. And now save. Fanny's Love Child. Oh, I gotta change the day 3 morning to day 3 afternoon. Let's just say day 3. I'll change that. But I'm now making this public. The details why it's not private. Make this public. Now come in here. Oh, save. Okay, now I got to go to my thing and redirect you all over there, but I'll take care of that. I'm going to redirect you all over there. Thank you for pointing that. You just reminded me. God bless you, brother. Last of the Yahoos says, congrats for more family. May God bless you with all grandchildren. Thank you so much. May the wind always be on your back. May the sun shine warm upon your face. Slainte. I hope you gave your new son a pick for the tunnels. Shalom. I will tell you this. All I'll share with you is this. His name is Daniel, and I gave him the nickname Danielson. So, there you go. That's my new nickname for him, is Danielson, which he said no one ever called him that before. So I said, it seems particularly fitting for me to name my new son-in-law Danielson. Danielson. I like that young man. He's a good man. So, I'm hiding from the shadows, babe. I come for your trials. Go to 7-Eleven. Get me coffee. I'm going to see you tomorrow then? I'm going to see you tomorrow? Is that what's going to happen? I'm going to see you tomorrow, CA? I hope so. All right. I need to redirect. I'm afraid I'm going to redirect. Let me redirect this thing. Can I redirect to myself? I should be able to redirect to myself, right? Oh, yeah. Look at that. Save. Done. It's redirected to myself. Oh, that's so cool. So cool. My first live show. Good Lawgic. No, I'll call you Great Lawgic. Thanks for a great. Oh, you're too kind. Thank you, Jennifer. I'm glad you called me live. 12 hours from now, I'll be live again. 12 and a half hours. Grifty says, I'm free if you decide to look at that tomorrow. I don't know. You see, tomorrow, here's the thing. Tomorrow, I'm going to be streaming in the afternoon, and then I'm going to be going to the party for like my kid, for the wedding, the post-wedding party, and then I'm going to be playing streaming in the evening. So my schedule is going to be pretty busy tomorrow. Proverbs 25:8. Do not bring hastily to court, for what will you do in the end if your neighbor puts you to shame? Nice. I like it. Getting all religious on me. We're going biblical. We're going biblical on you, Fanny. Going biblical. Fanny clearly perjured herself. That is a crime, isn't it? Will she be punished for this? We can only hope so. I hope so. I agree. I think she committed perjury. I think she committed terrible perjury. I mean, it's not like, here's the thing. It's one of the most public perjuries imaginable because this is a national hearing. This is not something you can just sweep under the rug that people are going to pretend they didn't see. This was seen by tens of millions. I mean, tens of millions of people saw her lie on the stand. This district attorney lying on their oath. I mean, tens of millions of people have seen this. How do you just pretend that didn't happen? She's really in trouble. When you think about it in that context, how the hell can they pretend that this didn't happen? It's so obvious that she was lying on their oath. I mean, everyone realize. We all know it. How do you sweep that under the rug? Crazy. Proverbs 26. Oh, all everyone's coming up with Proverbs tonight. Whoso diggeth a pit shall fall therein, and he that rolleth a stone, it will return upon him. Fanny and Wade are about to fall into the pit they dug for Trump. I agree with you. Bella Stella! You get the big horn. Gifting 10 Good Lawgic memberships. God bless you, Bella Stella. Thank you so very, very much. You're way too kind. So you are likely a new member of the following. If you're not, whether you're a new member of the following or not, I urge you, please make sure you like and subscribe. This is where people find me. This is your chance to find me, is what I'm doing, covering Fanny. So I urge you, please make sure you like and subscribe. Share with people. You want to clip that section where I was talking to Steve Sadow, make sure that he understands just how they definitely must be lying for the purposes of trying to hide their relationship. One of them has to be lying. They're saying completely opposite things, just so we know that Steve Sadow is going to put it out there. I feel confident that he saw it. He's the one who was hitting on it. He's the one who saw it. He'll probably throw it out. I'm confident he'll hit on in closing arguments. That they're lying. One of them saying Yurdi's there, the other saying Yurdi's not. I mean, they're flat out lying all the time, up and down. Terrible. Shamelessly lying. HPGKMC asks, what happens to other cases being prosecuted by Fanny and her harem? They get moved. Can other defendants point to this and seek relief? It's unlikely, because the whole point here is that this was motivated by an intent to help her boyfriend get money. So it's unlikely that this will have any direct impact on anyone who is facing prosecution in the state of Georgia. That's my take on it. Anyway, thank you so much, Bella Stella. Thank you, all of you, for joining me. Tomorrow, 1:45 p.m., I'm redirecting you all over to the next stream. So you can bookmark it. And in case you need to sleep or do something else, you can bookmark it, so this way you can be alerted to it. Please make sure you share it out there, like and subscribe. I want to have as many people in here so we can all salivate watching Fanny squirm as as Nathan Wade's former partner comes in there and is forced to spill the beans about all the ins and outs of their relationship that he saw long before the spring of 2022. And oh my God, it's going to be delicious. This is going to be delicious. It starts tomorrow, 1:45 p.m. right here on Good Lawgic. I can't wait to see you then. Don't forget, like, subscribe, share, and goodlogic.locals.com so you get notifications about when and where I am on everything. That's goodlogic.locals.com. I thank you all for joining me. Have a phenomenal evening, and I will see you all tomorrow afternoon for some exciting, freaking exciting stuff. Till then, I thank you. I'm going to land my plane on out here. You don't have to eat some bugs to stay happy right now. How can you not be happy? Everyone in society should be happy. We're seeing justice on its way to finally prevail, and the truth will set you free. Yeah. Oh, and one last thing. Judge McAfee, thank you so much. Thank you for working to actually institute justice, for not blinding yourself to justice. Thank you for being fair. Thank you for reminding us and reinstilling our faith that perhaps judges take their duties and their responsibilities seriously. And so far, I'm going to tell you, you seem to have taken everything about this case very seriously and very professionally. So I want to thank you for all of that, not the least of which, thank you for moving this up from Friday afternoon when I would be swamped to Tuesday afternoon. Thank you. See you all tomorrow, 1:45 p.m. Till then, stay happy, eat some bugs, and as always, Godspeed.